Let's delve into the operational aspects of the Companies Act in India, illustrating how it functions as a regulatory framework. The Companies Act of 2013 replaced the earlier Companies Act of 1956 and is the primary legislation regulating the incorporation, operation, and dissolution of companies in India. Incorporation of companies. Under the Companies Act, the process of incorporating a company involves several legal steps. Let's break down the key aspects. Name reservation. Procedure. Before incorporating a company, the promoters need to apply for the reservation of the company's name through the Ministry of Corporate Affairs, MCA. Example: if a group of individuals wishes to start a technology company, they might apply for a name like Techinnovate Private Limited, Memorandum of Association, MOA, and Articles of Association, AOA. Procedure. The MOA and AOA are documents that outline the company's objectives, rules, and regulations. These documents need to be prepared and submitted during the incorporation process. Example: in the MOA, the company might state that its primary objective is to develop and sell innovative technology solutions. The AOA would detail how the company will be managed and governed. Incorporation filing. Procedure. After name approval and MOA AOA preparation, the promoters file the necessary documents, including the application for incorporation, with the Registrar of Companies, ROC. Example: the promoters submit details such as the registered office address, details of directors and shareholders, and a declaration of compliance with legal requirements. Certificate of Incorporation. Outcome: upon successful review of the documents, the ROC issues a Certificate of Incorporation. Example: the certificate officially establishes the existence of the company, making it a separate legal entity. Day-to-day operations. Once incorporated, companies must adhere to various operational requirements outlined in the Companies Act. Board meetings. Requirement. The Act mandates that companies hold regular board meetings to discuss and decide on key business matters. Example: XYZ Limited, a company in the manufacturing sector, holds a monthly board meeting to review production schedules, financial performance, and strategic plans. Annual General Meeting, AGM. Requirement. Companies are required to convene an AGM at least once a year, where financial statements are presented to shareholders. Example: ABC Private Limited holds its AGM every year in September to discuss the annual financial results and future business plans. Compliance requirements. The Companies Act imposes various compliance requirements to ensure transparency and accountability. Filing of financial statements. Requirement. Companies are required to file annual financial statements, including balance sheets and profit and loss accounts. Example: LMN Limited files its financial statements with the ROC within the stipulated timeframe, providing insights into its financial health. Appointment of auditors. Requirement. Companies must appoint auditors to conduct an independent audit of their financial statements. Example: DEF Limited engages the services of an external audit firm to ensure the accuracy and reliability of its financial reporting. Compliance with corporate governance norms. Requirement. Listed companies need to comply with corporate governance norms as prescribed by the Securities and Exchange Board of India, SEBI. Example: PQR Limited, a publicly listed company, ensures compliance with SEBI's corporate governance guidelines to protect the interests of its shareholders. By adhering to these operational and compliance requirements, companies operate within the legal framework set by the Companies Act. Failure to comply with these provisions can lead to legal consequences, including penalties and, in extreme cases, the dissolution of the company. Understanding and navigating these regulatory aspects is crucial for businesses to thrive while maintaining legal integrity.